We're here today to announce a lawsuit that the state of Washington is filing against the three largest opioid distributors in Washington state. Those three entities are McKesson Corporation, Cardinal Health, and AmerisourceBergen Drug Corporation. These are Fortune 15 companies based on their 2017 revenues. Distributors work directly with pharmacies to supply them with pills. Opioid distributors are legally required to perform two critical functions, and you're going to hear this multiple times. Opioid distributors are legally required to perform two critical functions to prevent the flood of opioids into our state. Number one, they must stop shipment of suspicious orders. And number two, they must notify law enforcement when they do so. For years, these companies illegally shipped suspicious orders into our state. For years, they ignored their legal obligation to alert law enforcement of enormous, suspicious opioid orders. Their conduct, put quite simply, fueled the state's opioid epidemic by shipping staggering amounts of opioids into our state. Today I'm joined by a large number of folks. I'll introduce just a handful, including our speakers, but appreciate everybody who's here, including the extensive legal team and members of the public who are here. My legal team includes a few folks I'll introduce who've been working very hard on this case. Our Complex Litigation Division Chief, Jeff Rupert, also Senior Counsel Peter Helmberger, Assistant Attorney General Martha Rodriguez-Lopez, Assistant Attorney General Andrew Hughes, and Assistant Attorney General Tad Robinson O'Neill. These folks have put in long hours, in addition to many other folks on the team on this case, as well as our earlier litigation against Purdue Pharmaceutical. Today you'll hear from Quinault Nation President Vaughn Sharp. The Quinaults have also joined a lawsuit against opioid distributors and have played a key role in trying to bring accountability to what is frankly outrageous conduct. You'll also hear from University of Washington researcher and L9 Medical Director Dr. Gary Franklin, who has published more than 15 peer-reviewed papers on the opioid issue, including reporting some of the first deaths. You'll also hear from two mothers who are very personally impacted by the opioid epidemic, Tammy Waranka from Kirkland and Shani Jenkins from Olympia. Also joining us today is Rose Dennis. Some of you may recall Rose from a press conference we had some time ago now when we filed our lawsuit against Purdue Pharmaceutical. Rose and her family have been very impacted by the opioid epidemic, and we appreciate Rose being here again in support of this action as well. Just as a background before I get into the details of the litigation, some of the information that we have has been legally designated as confidential, so there are some limits to certain information that we have with this litigation, and we just have to be mindful of that. That is sometimes the case in lawsuits of this nature, but we're going to share the information that we are able to share, which is significant. Our team has reviewed thousands of pages of evidence and shipment data. We've seen the data, and it is shocking. The opioid epidemic has devastated Washington state families and wreaked havoc on our health system, all because these pills were flooded into the state in astonishing numbers. So let me be clear. These three companies had a legal obligation to be a key line of defense against the free flow of opioids into our state. Instead, they were driven by greed. If you ever wonder how an opioid distributor becomes a Fortune 15 company, you ship 2 billion opioids to one state alone, and you ship those pills no matter what. You turn a blind eye to your legal obligations and the human tragedy that results. They had a legal duty to report suspicious orders to the DEA. They were legally obligated not only to report them, but to stop those shipments as well. They did neither. How many pill mills might have been shut down if these distributors had simply followed their legal obligations? How many lives could that have saved? Today I'll outline how the actions of these three distributors fueled the state's opioid epidemic by ignoring these legal obligations to act as a safeguard. We'll also talk about what we hope to achieve from this litigation. We'll have other speakers as well, and then we'll take your questions. So these three companies supply the majority of opioids coming into Washington state. Between 2006 and 2014, during that time period alone, they supplied more than 2 billion opioid pills to Washington. As I mentioned, opioid distributors are legally required to monitor opioid orders they receive looking for specific factors that can identify suspicious shipments that could be diverted into the illegal drug market. So for example, if a pharmacy suddenly triples its order quantity, that's a red flag. Or if a pharmacy that typically orders once a month suddenly places an order once a week, that's a red flag. If they determine that the order is suspicious, distributors are legally required to stop the shipment and report the suspicious order to the Federal Drug Enforcement Agency. And I believe we have a chart that once we wrap up, you'll be able to see behind our many folks who are here that outlines those obligations. These companies fail to fulfill that obligation. In fact, even when their internal monitoring flags suspicious orders, the companies often ship them anyway without notifying the DEA. The DEA tracks every shipment of opioids. Much of that data is part of the confidential information that I mentioned earlier, but I can give you a general sense of the scale that we're talking about. So let me give you a couple of examples. In 2014, these three companies shipped enough opioids to Pend Oreille County to supply every single man, woman, and child in that county alone with dozens of pills. In 2009, McKesson alone supplied enough opioids to Pend Oreille County to supply every man, woman, and child with dozens of pills. These companies will say they had compliance programs, but if they did, they were compliance programs in name only. Using a very conservative calculation developed in a court case in the Washington, D.C. Circuit to identify suspicious orders, these companies shipped more than 250,000 suspicious orders to Washington between 2006 and 2014. Using a less conservative calculation developed in one of the other court cases against opioid distributors, these three companies may have shipped more than 3.5 times that many suspicious orders into Washington state, totaling nearly 1 million suspicious orders that should never have been shipped. To put this in context, a typical order contains hundreds of pills. These three companies have been sanctioned repeatedly for not monitoring and reporting suspicious orders. For example, McKesson has paid more than $160 million in fines since 2008, including a record-setting $150 million fine in 2017. The DEA determined the company filled, quote, hundreds of suspicious orders placed by pharmacies participating in illicit internet schemes, but failed to report the orders to the DEA. Cardinal Health has been fined 5 times for a total of nearly $100 million since 2008, including a $34 million fine for what the DEA called, quote, failing to report blatantly suspicious orders. The DEA suspended AmerisourceBergen's license in 2007 over not controlling shipments of prescription opioids to internet pharmacies. The DEA noted that between June 2008 and May 2013, one McKesson distribution facility, quote, processed more than 1.6 million orders for controlled substances, but reported just 16 as suspicious. These distributors had a legal obligation to stop suspicious orders and report them. Because they did not, more opioids flowed into Washington state. That led to, inevitably, more opioid prescriptions filled, more of these dangerous pills find their way into the illegal drug trade, more addiction, and more devastation. I do not have to tell you how crushing the opioid epidemic has been to Washington state and to our country. All you have to do is look at the statistics. Between 2006 and 2017, opioid overdoses killed more than 8,000 Washingtonians. On average, 2 Washingtonians die every day due to an opioid overdose. That's more Washingtons than were killed by car accidents or gun violence by firearms. The sheer volume of pills flooding the market is a key contributor to that devastation. In 2015, there were 8 counties with more prescriptions than people. So I want to be clear, that's prescriptions, not pills. There were more prescriptions than people. Clallam, Grays Harbor, Columbia, Garfield, Asoden, Pend Oreille, Lewis, and Benton. We have a chart you'll be able to see after we're done that outlines those counties. In 2008, there were 16 counties with more prescriptions than people. It is time to hold these companies accountable for the harm that they have caused. What we'll be seeking is the following. We allege that these 3 companies committed multiple violations of the Washington State Consumer Protection Act. As you know, the State Consumer Protection Act outlaws unfair business practices, and that'll be part of our litigation. We also allege that these companies helped create what's called a public nuisance, that's a legal term, public nuisance of the opioid epidemic through their negligent action. What does a public nuisance mean? In this case, the conduct of these companies has fueled a public health crisis, forcing the state and communities across the state to spend massive resources to try to address this crisis. In addition to civil penalties and damages, we're asking the court to order these three companies to give up the profits they made in Washington as a result of their illegal conduct. Sales of opioids are worth billions of dollars every year nationwide, and Washington's portion is expected to be in the many millions. The surrendered profits will be used to remediate the effects of the opioid epidemic, possibly funding treatment, education, and more. That's the goal.